Welcome to the Docketing Excellence Webinar Series.
Welcome to the Docketing Excellence Webinar Series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman Lundberg Wussner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together docketing experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on key docketing challenges and issues and share best practices on how to overcome them. The Docketing Excellence webinar series is free. To listen to one of our many past webinars or to register for future webinars, go to the Docketing Excellence Series tab of the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today is the 18th one in our overall series, and the third of 3 webinars specifically focused on best practices for efficient docketing of routine formalities. We've allowed time for questions at the end of the webinar. Questions may be submitted using the question button on the right-hand side of your browser window. You can submit a question at any time during the presentation. The question will be held in a queue until the end of the presentation. Before we begin, I want to let people know that Black Hills IP is presenting a free full-day docketing seminar in Chicago on September 7th and in Washington, D.C. on November 8th. The content of the seminars is different than the content of the webinars. So if you've listened to our full webinar series, the seminars will not be a repeat of the webinars. The seminars are interactive workshops with something to offer even for experienced docketers. To register for one of the seminars, go to the Docketing Excellence Series tab of the Black Hills IP website. The presenters today are myself and Jennifer Beaumentry. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I was a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center, which is now UNH, for 5 years. Jennifer, please introduce yourself.
Good afternoon. I'm Jennifer Beaumentry, and I'm a foreign filing paralegal with Schwegman, Lundberg, and Wussner. I've been here with SLW for about 9 years, and I handle foreign filing of applications for our clients. Prior to that, I was an in-house paralegal at Graco, and I handled U.S. and foreign applications and trademarks. And prior to that, I was with Merchant & Gould as not a paralegal, but an administrative assistant working with an IP attorney. So I've been in IP work now for about, I think it's 16 to 17 years.
Well, great. Thank you for joining us again today, Jennifer. Today we'll be covering formality requirements for Singapore, Saudi Arabia, Egypt, China, and the EPO. During the first webinar on the topic of formalities, we talked about why it's such a challenge to docket foreign formalities. For example, the doctor may be aware that something's due, but the doctor might not have the information needed to docket a specific due date or add a date to the docket. A common scenario that comes up is you have an agent letter acknowledging the instructions to file an application and explaining that certain formalities may be due, for example, 3 months from the filing of the application. But at that point, the application is not filed yet, so there's nothing for the docketer to add in terms of the specific due date. Then often what happens in the next communication from that same agent is the agent reports out the application. Now you have a filing date associated with it, but makes no mention in that second letter that something needs to be docketed because they've already told you that in the first letter. But if that letter is what would trigger the docketer to add something, there's nothing in the letter to trigger that. And oftentimes in a scenario like that, nothing actually gets added to the docket for the formalities deadline. In addition, requirements and deadlines vary from country to country, which makes it confusing. Some countries have deadlines that are based on a date of notification from the Patent Office. Other countries have deadlines that are based on a filing date. Again, it can be confusing. And on top of that, the foreign agent communications are sometimes unclear as to what the actual PTO deadline is and what is their internal deadline that they're requesting instructions from you by. For example, as we were preparing for an earlier one of these webinars, we were corresponding with an agent to find out what the deadline was for submitting a certified copy of a priority document. In that example, we had consulted two different agents, and one told us 60 days in that country and another told us 180 days, and it was the same country. What we later figured out was one was an internal deadline, but that earlier 60-day date, it was not clear, was not clearly stated in the letter that that was an internal deadline. It came across as that was what the agent was telling us the Patent Office deadline was. So the bottom line is there's a lot of room for error and for confusion when dealing with docketing deadlines for formalities in foreign countries. The more you understand the requirements in those countries, particularly for the countries that you're frequently dealing with docketing the deadlines, the less likely you are to have a serious docketing error. So let's get started with Egypt. Jennifer, can you talk about Egypt?
So in Egypt, the certified copy of the priority document is the first bullet that we'll be discussing. If you filed a national stage application in Egypt, the certified copy of the priority document is not required. It would only be required if you filed a direct application in Egypt. For instance, at the 12-month Paris Convention deadline, you would file direct into Egypt. In that instance, the certified copy of the priority document will be due 3 months from the filing date of the Egyptian application. This deadline is not extendable, and the original certified copy is required. And finally, an Arabic translation is also required. Moving on to the power of attorney, the agent will provide you with the power of attorney document for signature in Arabic. The deadline for the submission of the power of attorney is 4 months from the filing date in Egypt. This deadline is not extendable and the original document is required. Now, this document has to be legalized up to the Egyptian embassy. And we're showing you right now an example of what a power of attorney for Egypt might look like. On the right-hand side is the Arabic, and on the left-hand side will be the English. So you will know exactly how to instruct your clients to execute this document.
And Jennifer, I thought this was interesting to include because when we were working on this and you told me you had to submit the power of attorney in Arabic, I thought, well, how does an inventor sign off on that when they can't read what they're signing, obviously? And you explained to me that typically the agents will provide you a power of attorney in a format like this with the 2 columns with the English on one side and the Arabic on the other, and I thought that was interesting and wanted to share that with our audience if they hadn't seen that. So this is not the full power of attorney document. There's a little bit more to it, but we just pulled the first couple paragraphs so you could see what that looks like.
Oftentimes you'll see something similar coming, for instance, from a Brazilian associate or another in other South American countries. Well, you'll have a document that's split in half, English on one side and the native language on the other.
Good, thank you.
For assignments. In Egypt, the assignment would also be due 4 months from the filing date of the Egyptian application for a direct filed application, and only if the priority document was filed in the names of the inventors. This document will need to be executed and legalized up to the Egyptian embassy. Certified copies from the United States Patent and Trademark Office of the U.S. recorded assignment are not required. The original document, the original assignment document, is required to be submitted to the Egyptian Patent Office. Scanned copies will not be acceptable. The assignee signature is required, and this deadline is not extendable. The translation of the application is filed in Egypt. Yes, it must be translated into Arabic. And then other documents for or requirements for Egypt would include a legalized certificate of incorporation or an extract from the commercial registry is required for direct filed applications, and that's due within 4 months from the filing date in Egypt. And if it's a national stage application in Egypt, just a simple IB 306, the notification recording of a change, filed with after the PCT publication. Going back to the assignment documents and the power of attorney documents, where we mentioned that the document has to be legalized up to the Egyptian embassy. This is a process where the document itself has to be notarized or legalized in the state where it was executed by the Secretary of State of that particular state. And for an example, if we have a document that's been executed here in Minnesota, it would have to be legalized by the Secretary of State of Minnesota. Then that document would be sent to Washington, D.C. to be legalized at the U.S. Department of State. And then the final step would be the document would have to be legalized by the Egyptian embassy. This process takes a lot of time and can sometimes be expensive as well. Some firms will use a legalization service in Washington, D.C. to handle the Department of State, Secretary of State of the U.S., and also the Egyptian embassy, and that will require fees on their part, and then time to get that legalized document back to you to send on to your Egyptian associate. So when you have formalities in Egypt, you need to give yourself a lot of time in order to get these steps completed, or that document, when you finally get it and send it to the Egyptian associate, may or may not be accepted by the Egyptian Patent Office if it's not been legalized properly.
Good. So you definitely have to allow time for that process, and that's something to think about from your docketing strategy too. Do you have reminders ahead of time or something to trigger that so you're allowing that amount of time for that process to happen? Let's talk about Singapore next. Singapore is fairly straightforward. You do not need a certified copy of the priority document. A power of attorney is not required. And you do not need to submit evidence of an assignment from the inventors to the applicant. So far, pretty easy. If the PCT application was not filed in English, you do have to submit an English translation. What is a little different about Singapore is that in addition to the English translation, they also require that you submit a verification statement from the translator. The verification statement can be filed with the application at the time that it's filed, or if not, then it has to be furnished within 32 months of the earliest priority date. Or if you actually happen to be filing earlier than the national phase deadline, then your verification statement is due within 2 months of the filing date of the application. So note that you do not need to notarize or legalize the document. You just need to have this verification statement. And I'm going to jump to the next slide because I have an example of what a verification statement, what the wording of a verification statement might look like. And it's just a statement by the translator that they are conversant in the English or in the language that they're translating into, as well as English, or that they're translating into, as well as English, and that they are the ones that did the translation, and that it's true and correct English translation of the specification of that PCT application. Likewise, if there had been amendments made during the PCT process, like Article 34 amendments, for example, a verification statement similar to this would be needed to be included for the translation of those amendments made during the international phase. And jumping back for just 1 second, with respect to the IB 306 form, there seems to be a bit of a delay here on my slides. Here we go. Whoops, now they all come through. If there are changes made after the PCT publication in Singapore, the IB 306 form can be submitted for recording those changes. So, Jennifer, let's go on to Saudi Arabia.
Saudi Arabia is going to act in a similar way as to Egypt in terms of the formalities, and so we'll go through those. The certified copy of the priority document, if you have filed a direct application in Saudi Arabia, is due 90 days from the filing date of the Saudi Arabian application being lodged with the Patent Office. This deadline is not extendable. However, if you get right up onto your deadline, a scanned color copy can be submitted to the Patent Office, but the examiner may request the original copy. There's no need for an Arabic translation. However, the English translation will be required in the same case and the same language other than English. For the power of attorney, that's also due 90 days from the filing date in Saudi Arabia, and that deadline is not extendable. You're going to go through the similar processes in Egypt to legalize that document up to the Saudi consulate. You might remember that we said Egyptian embassy. This time we're saying Saudi consulate. It's just a function of what that particular country calls their either embassy or consulate in Washington, D.C. A scanned color copy of the power of attorney can be submitted to the Patent Office again if you're up on top of your deadline. However, the examiner will request or may request the original copy. With the assignment document, you also have 90 days from the filing date of the application in Saudi Arabia, and again, not an extendable deadline, and it must be legalized up to the Saudi Arabian consulate. An Arabic translation of the application also must be submitted to the Patent Office in Saudi Arabia. And other documents or requirements that we have that are particular to Saudi Arabia. If you filed your PCT application and there are changes after the publication, but before the national stage application is filed in Saudi Arabia, a simple IB 306 notification of the recording of a change will suffice. If the national stage application has been filed in Saudi Arabia and there have been changes made and the application has been filed, you're going to be required to have the documents to be submitted, for instance, a power of attorney from the new owner or an assignment for the new owner. Those documents will again need to be legalized up to the Saudi consulate, much as you did or have as we outlined above. And you will go through that same process with legalization by the State Secretary of State, the United States Secretary, Department of State, and then the consulate level legalization.
All right, now let's talk about China.
With China, we have no requirements for the priority document to be submitted if it is a national stage application. The certified copy of the priority document will only be required for direct applications filed in China. The deadline for the submission of the priority document will be 3 months from the filing of the Chinese application. This deadline is not extendable, and a scanned copy of the full version of the priority document will suffice. An original is not required. For the power of attorney, it will be due 2 months from receipt of the document called Notification to Make Rectification, and that's issued by the State Intellectual Property Office in China. This deadline can be extended once. by 2 months. A scanned copy of the specific power of attorney for an application will suffice. If you have a general power of attorney for your firm in China, the original document will be required to be submitted.
Okay,
with the assignment in China, it will be due 3 months from the filing date of the application with the Chinese Patent Office. The deadline is not extendable, and as long as the assignment is executed by the assignee and the assigner, a scanned copy will suffice. Notarized copies are not required. The certified copy of the U.S. assignment is not mandatory. The scanned copy, again, of the executed assignment by the assigner will suffice. For the translation of the application as filed, the PCT application, if you're filing a national stage application in China, a PCT, the translation must occur into Chinese, but SIPO allows an additional 2 months beyond the 30-month deadline to get this accomplished with the payment of a fee. If you're filing a direct application in China, that translation will be due at the time the application is filed. Other documents or requirements for China include the notification of the recording of a change after the PCT application has been published. The IB306 will be acceptable, except for a power of attorney if there's another entity that's involved. And in case the name change to the applicant or the inventors, a certificate of changing name must also be filed. So going back to some issues that we have with the assignment, if it involves the transfer of a priority right, assigner and the assignee's signatures are required. If you're filing a direct application, and this is talking to the translation of the application, that document has to be translated if you're looking at a 12-month deadline and you're filing direct in China. Usually, the Chinese associate will request that they receive that translation a month ahead of your 12-month deadline. We all know that sometimes our applications aren't ready at that point, so there may be some issues that you're looking at trying to get that specification and drawings translated in a timely manner to get that application filed. What we're looking at here now is you're probably going to incur rush translation charges if you're getting really close to your 12-month deadline. You have a couple of different options to think about. If you're getting close and you're still rewriting the or still making changes to that application, or it's not in its final form, if you have either an inventor, a Chinese inventor or a Chinese national involved in your application, there would be the possibility of filing a direct PCT application in China with China as the receiving office. You could file that application in English if you have someone that's a resident or a national. If you don't have a situation where either an inventor or your applicant is a resident or national of China, you're going to have to think about offsetting the costs of a rush translation against possibly just filing a normal PCT application with the U.S. as the receiving office at that 12-month deadline. Things you're going to want to look at is pages in your specification. If you have a large application and you're a week from that 12-month date, you may want to just shoot off a quick email to your Chinese associate and say, we're considering a direct filed application. We think our specification is going to be 45 pages. Can you let us know what your rush translation charges are? And then you'll be able to make a more informed decision about whether or not you still want to go forward with a direct application in China, or whether you just go with a straight PCT application in the U.S. and then file a Chinese national phase application.
Good tip. I have a question for you. So when we were preparing for this, well, you talked about the fact that the 3-month deadline for the priority document and the assignment in China is not extendable. But yet you showed me an example of a case you've worked on recently where you got those dates extended. So what do you make of that?
The application I was working on was a utility model application, and that utility model claimed priority to an actual PCT application. And it was kind of an odd instance because not a lot of clients choose to file a utility model. We got that document from our Chinese associate, the notification of, I think it's called, notification to make rectification. And I was able to get a 2-month extension of time. We were having some troubles getting inventors to execute that assignment. So I was able to get a 2-month extension of time. We had been able to get the power of attorney executed, but not the assignment. Mm-hmm. And we did get an extension of time for that case.
So from a docketing standpoint, I would say treat it as a 3-month deadline. If you think you're going to have trouble meeting that, then contact your agent well in advance to see if there is some way to extend it. But I would treat it as not extendable just to be safe.
Yes, I would definitely treat it as a not extendable deadline. And always in an instance where you have questions, your agent will be able to tell you
what your options are.
Right, exactly.
The other thing to remember about China, and particularly with respect to docketing deadlines in China, is that they have the mailing period. So we've done at least one webinar where we've talked about how to correctly calculate deadlines in Europe and in China. I don't want to go through all of that again, but essentially there's an initial period for some deadlines that is considered the mailing period, and then the 3-month period, 3-month deadline would be added on to that. And I'm not quite sure in this instance when it's calculated off a filing date if that mailing period applies or not, but just remember on some of your Chinese dates that mailing period is calculated on the front end and not on the back end. It's not a grace period.
You may also want to check with your agents on these formality documents for China. They've recently adjusted some of their rules. We used to have to file original documents for powers of attorney and assignment documents, and now they've kind of relaxed their rules and scanned copies are acceptable.
Interesting. All right, well, the last country we have on today's list is actually not a country, it's a regional patent office, the EPO. And I'm sure many of our listeners have experience with the EPO, and this will be a review. But certified copies of priority documents are due 16 months from the priority date. If you do not submit one by that deadline, though, you will get a deficiency notice from the EPO that sets a new deadline for filing. And you may not know that the USPTO can exchange priority documents electronically with the EPO and some other patent offices through electronic connection that's called an Electronic Priority Document Exchange, PDX. There's no cost to do this as long as you have requested that, and there's a form, USPTO Form SB39, allows authorization to permit access to the application by participating offices. Also, I believe the ADS has a box that authorizes the transmission of the priority document to participating offices as well. So getting your priority document to the EPO from the U.S. should be a fairly easy thing to do. No power of attorney is required for the EPO, and an assignment is not required either, but if you do choose to record one, you can use a scanned copy, but it has to have both parties' signatures on that document.
Before you move on to your next slide, Anne, going to the European Certified Copy of Priority Document, what we often do at SLW is send a quick note to our European associate, and we ask them to confirm that they will get that priority document through either the PDX or and we also send them a copy when we send them our filing order form of the SB 39 that's been executed, so they have that for the records.
Good. Good. So yeah, so it should be fairly easy to get the priority document to your European agent, right?
Right, and they'll confirm that, they usually confirm that they will do that, and there's no other actions required on our part.
Good. All right, moving on to translations. Again, as most of you probably know, if an application is already in English, and most of ours would be, then no translation is required. And for other changes made after PCT publication, you can use the IB 306 form to submit those changes. So today we've talked about the specific formality requirements for Singapore, Saudi Arabia, Egypt, China, and the EPO. Across the 3 webinars, I think we've covered probably close to 20 different countries and their individual requirements. But if you want additional information on those countries or countries that we haven't covered, I highly recommend the Pct Applicants Guide. The Pct Applicants Guide is available online at the WIPO website, and it includes specific detailed information on individual countries. And so if you go to the Applicants Guide and then you go to the Introduction to the National Phase section, that will include an individual page for each country detailing the requirements that we've gone through, as well as a number of others. So that's an excellent resource.
One other thing I wanted to mention, Anne, if you're going to file national stage applications from your PCT application, it's important to make sure, either by checking the WIPO website or the documents you've received from your receiving office and searching authority and stuff, to make sure that they have actually transmitted that priority document, that your receiving office has transmitted, or that the document, your priority document, has been transmitted to WIPO. I've had a case or two where I filed a national stage application in Japan, and the priority document had not been made available, and I was asked for it by the Japanese Patent Office, and I
hadn't been provided to WIPO yet.
Right. And they needed that document, so I actually ended up having to call. It was a U.S.-based case, so I called the USPTO and made sure they were our receiving office and made sure that they transmitted that priority document.
So you're saying that prior to starting the national phase filing process, it's a good practice to somehow build into your workflow checking to make sure WIPO got the priority document, and whether that's a item that you docket to check, or it's something on a checklist for the process for the paralegal at some point during the PCT process, that can head off and save a lot of trouble down the road in your individual national phase countries, and prevent having individual requests from 3, 4, 5 or more different countries that didn't get the priority document through the PCT, right?
Right. We mentioned that in all the countries we discussed, that if you're filing a national stage application, a certified copy of the priority document isn't required, but it can cause trouble if it hasn't been transmitted to WIPO.
Well, another good tip, Jennifer. I appreciate that. You have a lot of great experience to share. So if you have questions on today's program, those can be submitted using the question button on the right-hand side of your browser. If you have questions about Black Hills IP, services or our processes generally, please contact our Vice President of Sales, Jim Brophy, and his contact information is on the screen. We will be posting the slides so you can download them, as well as an audio recording of today's program on our website under the Docketing Excellence Series tab of www.blackhillsip.com. So let's take a minute to let people submit questions if they have questions. I have one for China specifically. What is the certificate of changing name?
I believe it's a document that your associate or agent in China will send you, and you will need to get it executed. It would be something similar, or you could file something similar to corporations that are registered in Delaware and they file with the Secretary of State of Delaware to change their corporate name. It would be a document similar like that, but specifically for China.
So it's not an assignment. No rights have been transferred from one entity to another.
Yes.
But the entity that's the owner on record has a change of name. So it looks like it's a different entity, but it's merely just a name change.
Correct.
For the owner, right?
Yes.
Okay. If a country is part of the patent prosecution highway, is a certified copy of the priority document still required? That's a really good question.
It is a really good question, and I don't think that the patent prosecution highway procedures have any effect on whether or not a national patent office needs a certified priority document.
Right, I would agree with that. I don't think the PPH process changes any of the formality requirements. It just accelerates your substantive examination of the claims.
Right. I think, as a matter of fact, I know that Japan and China, I think, are both party to PPH, and we still follow the same formalities in those countries. And later on down the line, at the time you request exam, or if you request examination at the time of the filing and decide to do patent prosecution highway, the documents for formalities are still needed, and you have to fulfill those deadlines.
Mm-hmm. I don't think it waives those in any way. Okay. How often do you find yourself having inventors sign/notarize multiple copies of assignments due to several different countries requiring the original documents? What's your experience? You're smiling, Jennifer.
We do this quite often, and I've actually had a couple clients ask me recently, is it possible to use the electronic signing convention that's acceptable to the USPTO for these foreign documents? And I'm in the process of investigating that, but I believe that you can't use the convention that is acceptable to USPTO with the slash,
yep,
the type and the slash. They're still I think many countries still require that signature. So we struggle with that all the time, and it's the same if you've nationalized an application in a couple of different countries, or if you've filed direct in several countries. We're still sending out powers of attorney and assignments for multiple countries to these inventors, and also to your client for different powers of attorney.
So frequently you
yes,
find yourself doing this. So it's a common problem, and there's really not a lot at this point that you can do about it, other than planning for it and making sure the inventors know that and understand why they're getting multiple copies.
Exactly, and then also making sure you know when a scanned copy is acceptable versus an original document that has to be DHL'd to a foreign agent.
Yeah, and some of the countries we have talked about over the series of the 3 webinars we've done do require original copies.
And you have to recall, it's really funny, in this age of everything being instantaneous or everything able to be emailed, to get an original document from the United States to, say, Beijing or Riyadh or or some other part of Saudi Arabia, it's not an overnight thing. So you have to plan. I would even check with DHL to check delivery times once that package gets sent, because you might be up on a deadline and it may take a week to get something to Beijing or a week to get something to Saudi Arabia, and you need to build that time into your whole timeline for those formal documents.
Yeah. That's why the foreign formalities are complicated. Our client did not keep the original of the power of attorney they signed for our foreign associate. In this case, it was for Mexico. At the time, they filed a direct national filing in Mexico. Does the date of signature have any bearing, i.e., is it fine to have them execute the power of attorney again so that we may send them an original?
I've actually had this come up a couple of different times. They didn't keep the original. They scanned the copy in and sent it to us, and we sent it on to the associate. And I kind of go back and forth on what to do with this one. If they're going to re-execute a power of attorney, I have them re-execute the power of attorney on the date and date it to the day that they executed. Yeah.
Yeah. And that would be a great question for the agent. That might also vary from country to country.
Or sometimes even from agent to agent within a country.
Oh, yeah. Yeah, exactly. Okay. Mexican law recently changed as regard to the need for the assignee to sign an assignment when the assignment is between companies, not between inventors to company. It appears that some other countries require execution by the assignee when it's an assignment from the inventors. Do you use various assignment forms for the priority application to ensure it will be accepted by different countries?
So it seems here we're talking about kind of a couple of different things. We've got an assignment from the inventors to the one entity, and then you're also discussing assignments that go from, like, what I would think of as an intra-corporation assignment from company to company. So I'm going to answer this question when it talks about execution by the assignee when it's from the inventors to a company entity. And recently, Europe changed its rules on that, and we also occasionally have trouble with China. We're moving towards having the assignee execute that assignment when it goes from the inventors to the assignee. So there would be a line on the assignment to have the assignee accept that assignment. So I think that every country is still going to be different, but I think because of Europe changing its rules, they actually didn't change their rules. They always had that rule, but now I think they're enforcing that rule. So we're kind of moving towards just going with the assignee signing that assignment for everything, yeah.
Then you know it will work. That's a safe way. And this is just a follow-up comment from one of our listeners. A worldwide assignment, including the U.S. and PCT applications, will be accepted by most PCT countries if it's signed, assuming also that it's signed by the assignee and the inventors. So that goes along to your comment, right? Just get both parties to sign,
right,
so that you have it. And a follow-up comment as well, most countries will accept a general power of attorney from the assignee to the foreign law firm, and I'm assuming this person means as opposed to a specific power of attorney.
Right.
As well.
We have several clients that absolutely refuse to execute a general power of attorney. They want a specific power of attorney for every application that they file. So I think it's just in accordance with whatever your client prefers. The other thing to remember is sometimes you're not using the same associate. So you're going to have to execute another power of attorney if you use a different firm.
Yep.
So
So when you can, though, it would be useful to have a worldwide assignment covering everything assigned by both the inventors and the assignee, and then a general power of attorney from the assignee to the foreign agent. And assuming that the individual country will accept those things, that's an easy, good way to do it.
I've never seen any trouble with a general power of attorney that's executed by the assignee to the foreign law firm, but it's just a matter of whether that particular client has a preference between a general power of attorney or a specific power of attorney for your application.
Okay, so it's client preference. It's not so much the patent office.
Exactly.
Okay. And I just want to add one other comment that we had from Nicole, and this came in, I believe, during the discussion of Egypt when we were talking about having things legalized and that whole process. And the comment was, I often have to add a notary block to the documents that the agent provides because you can't have it legalized, obviously, if it's not notarized. And that's a good comment. It's kind of assumed, but that's a good comment.
You know what we often do, Anne? We'll occasionally have a notarial certificate that we put on some of the assignments, and the notarial certificate gets notarized. Oh,
so you notarize the notarial certificate?
Yeah. It's a notarial certificate that has a descriptive paragraph about the document, and it lists out the we do this for Mexico occasionally, and it will list out the actual, this is an assignment, and it regards this specific serial number that was, and this is the date of the filing of the application, and we attest that, and then we have the notarial certificate notarized, and then we send that to the Secretary of State.
Following up on that, another question that just came in. Do you recommend always having U.S. inventor signatures on assignments notarized in case it is needed or preferable for foreign filing later on? Is notarization preferable over a witness signature?
I think it varies from country to country. Obviously some countries, like for instance, Europe, they don't require notarization. So I have a lot of clients who will regularly have that assignment. They'll add a notarial block to the assignment. But it depends on your client and how they, sometimes they have their own assignment documents. And I would say, though, that a notary, if you're going to have I think probably a notary would be better more universal and more universally accepted than a witness signature.
I would agree with that. I think that's a good recommendation. Well, these have been great questions, and I want to thank our audience today and tell you about our next webinar. On August 16th at 1 p.m., we'll be doing our next webinar, which is on docketing response dates in countries having acceptance deadlines. And then we will also be announcing several more webinars very soon. This is the last one we have currently posted, but there are many more coming. We're working on that list of topics and plan to continue about one webinar a month on the docketing webinar series, as well as announcing a couple of new webinar series in addition to the docketing webinar series. So we'll have details on that. If you watch our website, those will be coming out soon. So to register for these webinars, go to Black Hills IP's website. And thank you again for participating today, and thank you for all the great questions we had from the audience. We hope you'll join us for this and other webinars in the Docketing Excellence webinar series. And also, if you haven't joined our LinkedIn Docketing Excellence group, we're starting to post content through that. I know we've had a couple of posts about searching the tips and tricks for searching the Japanese Patent Office website, searching the Brazilian Patent Office website. Our analytics specialist, Jackie Spertel, has provided some great insights and has some additional countries, many additional countries actually. She'll be posting tips on our LinkedIn website, our LinkedIn group. So please join that as well. Thank you very much.